Salutations. This is Stanley Zamor, Florida Supreme Court certified mediator, family, county, circuit civil, primary trainer, qualified arbitrator, and a bunch of other things when it comes to helping people resolve conflict. You know, conflict is inevitable, but the selection of your resolve is yours. How you get it done. So today I just had a mediation, and why I'm creating this video right now is because I've gotten recent phone calls from a lot of individuals who are a little bit upset, or they're actually not sure to say individuals, they're mediators, professional neutrals, who are a little bit upset that they cannot get their disputants, the people bringing the actions or defending the actions, to come to the table and get her done, and they're ending in an impasse, an impasse or no agreement. And I tell them, ending in a no agreement is not such a bad thing. And today, what just happened a half hour ago is an example of that. For example, so we had the insurance company came, and they had the general counsel, which is rare. You don't have a general counsel that comes, but they were there. I guess it was a case big enough, so whatever. General counsel came. They had an adjuster there. Okay, then they had the other side, the plaintiff side. They had the husband and the wife, and they had the insurance their attorneys. So I did what's called an orientation session. It's the beginning of the mediation, where the mediator kind of gives some instruction and orientation as to how he will or she will facilitate the process called mediation. There's a number of things that go into that. I'm not going to get into them. I'm just go into what I said about possible outcomes. Now, a technique and style that I like to employ, that I always encourage people to do, I do advanced trainings for mediators, attorneys, those who negotiate for a living, on advanced negotiation techniques and skill sets. Correct. I always mention types of outcomes, possible outcomes. What is the end result of today? Why? To set them up and understand. They have an expectation in their mind of what they think it should go, or how they think it should go. And I guarantee you, whether it's on the plaintiff side, petitioner, respondent, defense side, whatever it may be, they were prepared. Hopefully, they were prepared for what mediation is and what it is not. And I'm just going to say it, sometimes they're not as well prepared as they thought, or because there may be a language barrier, or because they do advanced research themselves on, let's say, the Google or some other means of learning what mediation is, or hearing from neighbors, or he say, she say. They have expectations that they come into the process with. So I think a good thing to do for mediators is to reset those expectations, and do that continually. Now, I do some seminars, 8-hour-long seminars, for those who want to learn how to do that. I can show you. It's not as complicated as it may appear, or you may think. It's not as simplistic either. Some say, whatever, their lawyer will tell them. No. It's the responsibility of the professional neutrals to reset those expectations. But it's the awareness of the neutrals who understands when to do it and how to do it. That's the key. That's a technique. That's the advanced awareness I think you need to learn and have. So nonetheless, in this one, I kind of help them understand in the very beginning what possible outcomes are and what to expect. And I went into it in a concise, quick way that I saw touched them a little bit differently. So we went to separate rooms called caucusing, meeting separately in breakout rooms, right? They came with a certain number, and I told them again, you're going to have expectations of a number you might want to hear. You may not hear that number, but it's okay. It's what happens. And then the response will be something you may not want. It happens. But we reset expectations because mediation oftentimes is a place where you can learn more about your case as well as the case of the other side. But more importantly, what are your thresholds? How can we reset those thresholds? What can we gain from the process to learn more? So if it ends in an impasse, it can be a constructive impasse, because you will construct a different way to build on what you know as things that can happen, things that can be resolved, and have a written settlement agreement later on, if you both choose to do so. So guess what happened? The other side said, we have a certain amount of dollars for today that we know, but since they said this, since we just saw and heard what you mentioned as far as getting it done today and possible outcomes, can you advise the other side that we just don't have enough information to even come close to the demand we just heard? So we don't even want to make an offer because it'll be insulting. There's things that are still pending that makes us not able to give them a more effective number, okay, a more acceptable number. And thank you for making those references, Stanley, because now we can piggyback on that and tell them we want to resolve the case. Let's come back. Let's adjourn. Or let's call it an impasse. But because we know what we know so far, because we've heard what we heard in opening comments, opening statements from both sides, we can build on what we still have going on. We can build on discovery that's outstanding, get those questions answered, so we can request more money from the higher-ups maybe, and get it done for a higher amount. But today, if we give them an amount, which is not a bad dollar amount, but given what we heard, we do know they won't accept it. So I went back to the other side of that and I explained it just like what I just told you, that the resolution opportunity is there. You will resolve today. The type of resolution, though, for today might be a little bit different. And here's why. And I went into it, explained certain things to them a certain way, used their attorney to help back up what I was saying. This could be a constructive thing, not a destructive thing. And they were very appreciative. Both the defendants were the plaintiffs were very happy. I'm using the word happy. They were actually relieved because they know that a lot of things they knew needed to get done, but they didn't think they get a chance to do them. Okay, expert witnesses, more depositions, some more things that are out there, and they received it. So I closed the rooms out, had a joint session, and again with an upbeat personality, explained to them, thank you for allowing me to be your mediator, and from what I understand, here's your current plan of action. Boom, 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 boom. So this can get resolved in a different type of way. That might be a settlement agreement, for example, in a later date and time. And I will always be available for you to assist with that. They all left smiling. They all left. The husband was like, he feels better about litigation. He feels better that they can probably get this done, but a little bit later. And that's what's the important part. The things that mediators need to understand, the neutrals, your job is not to get them to a settlement agreement. That's just one of the options, okay? Is to get them an opportunity to facilitate exploration of possible outcomes that's proper and correct for that day. And they're going to come back potentially. I've had it happen hundreds of times. They're going to come back when things are more settled, and then settled in the sense that more information is settled down. They can make more informed decisions. And at that point in time, they'll have a different resolution after we negotiate. So lead with the positive. Lead with understanding that mediation is okay and can end. You can have a constructive impasse that sets up how you could better resolve cases later on. So with that, thank you. Next time, share the information, comments, look me up, text me, email me, call me. Let's have a conversation on how to make better solutions, all right? With that, have a good rest of your day.